You are outraged, you are furious at the defense's lowball settlement offer, and you say, I want to go to trial, and make sure that when we go to trial, do not notify the defense of which experts we're bringing in. I want you to ambush them at trial. Can I do that? Is that permissible? You want to know the answer? Come join me along this walk as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, I cannot do that. No matter how outraged, no matter how furious you are at the defense's lowball settlement offer, if your case goes to trial, I am obligated by law to notify my opponent that I have hired and retained a particular medical expert or medical experts. And I am required to tell my opponent exactly what my experts are going to be testifying about. That is critically important. You know what will happen if we go ahead and go to trial, and now on the day that my expert is supposed to come in and testify, what will happen? Here's exactly what will happen. Your Honor, at this time, plaintiff calls Dr. Jones to the witness stand. My opponent jumps up out of his seat as if an ejection button has been pressed and yells out, "Objection, Judge! Mr. Oginski has failed to disclose the fact that he was bringing in this particular expert. And because of that, I ask you to prevent his witness from testifying. We call that precluding the witness." Now, what will the judge do? The judge will turn to me and say, "Mr. Oginski, is that true? Did you fail to notify your opponent about the fact that you were bringing in this witness?" "Well, yes, Judge, I wanted him to be surprised." "Very good. Now, I am precluding your witness from testifying." "But Judge," No, counselor. You have an obligation to disclose the fact that you are bringing in a particular expert, to give the opposing attorney an opportunity to prepare fully for cross-examination. What you have done here is you've done basically trial by ambush, and that is not permitted in today's day and age. You have failed to give him an opportunity to learn about the details of exactly what this witness will say. You have failed to give him the opportunity to dig up any dirt in order to prepare for cross-examination. And because of that, that is inherently unfair, and I am now going to prevent this witness from testifying. Which, in your case, since this is your only expert, your case is going to be dismissed. Now, that is deadly. Why? Because if we can't go ahead and have this witness testify, we can't prove your case. In medical malpractice cases in New York, we are required to have a medical expert to confirm, number one, that the doctor was careless. Number two, that his carelessness was a cause of your injury. And number three, that your injuries are significant and or permanent. If we no longer have a medical expert available in order to testify, guess what? Then we can't prove any of those things. And that means that the judge is correct, that he's going to have to throw out your case. Why? All because you wanted to be spiteful because the defense made a lowball settlement offer. Any attorney worth his salt is going to tell you straight out, I understand you're frustrated learning about this lowball settlement offer. However, we have an obligation to notify the opponent, our adversary, the defense lawyer, of exactly who we plan on bringing in at the time of trial. Likewise, the defense has a similar obligation. If they plan on bringing in certain medical experts or certain witnesses, they also have an obligation to notify us that they are bringing in these various witnesses. So why do I share this quick information with you? I share it with you because this comes up sometimes where the client is so frustrated with the settlement offer, the client wants to do something to exact some sort of retribution, not realizing the effect it's going to have at the time of trial. So why do I share this with you? I share this with you just to open your eyes and help you understand how these types of cases work in New York. You know, I realize you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.